this is from the Paul and Sandy's home of the People's Health Alliance in Shoalwater, Western Australia. So we've got a lot of material to cover, so we'll go through as quick as we can. I wanted to start off with this idea. It's not what we don't know that makes us ignorant, it's what we don't want to know. There are many things, we all don't want to know lots of things. I'm not particularly interested in a lot of things, and I'm completely ignorant about those things. So it's just a general principle. We'll be talking a lot about principles in this presentation. So the first thing that we want to talk about, the reason that a lot of us are here is because we felt in the last few years a serious infringement of our basic rights that we all possess. So we want to talk about just briefly about the origin of rights and from whence comes law. Where does law come from? And this law derives from rights. When there's a general agreement about rights, law will follow. When everybody agrees, okay, we've all got the right to be free from aggression, for example, or from theft, all those type of things, then once people agree with that, that becomes generally accepted as a law. It's a law that is a natural law. In other words, it can't really be changed. We'll go into that a little bit more shortly, but rights become recognised when people follow their consciences, realising that others desire the same things that we need ourselves. So that's the origin of the natural common law, which is enshrined in any worthwhile constitution. When we talk about rights, there are two types. There is basically natural. We call these negative rights because they don't cost anybody anything. We don't require anything from anybody else in order to be able to exercise these rights. We need to be free to seek our survival needs, free from assault or coercion, free from fraud or deception. These are what we call negative or natural rights. We're all born with these. Right? Every living thing comes into the world with these sort of rights to sustain itself. A tree or an animal, they all have got the same type of rights. That the trees don't talk, of course, but they've got the right to sustain themselves. These ones on the other side are what we call legal rights, and they're positive. In other words, people claim these things like a right to an education or a right to free healthcare, a right to welfare, a right to home or shelter, right to a minimum wage. There's an endless list of things that people like to claim as rights, and there are implications about these two types of rights. The negative ones exist in and of themselves. There's no grant necessary or even possible. Nobody can grant these rights or take them away. They impose no demands or cost on others. They can only be removed by force, deception, or if the person consents to it. Being part of nature, they're immutable or eternal. They're not like natural laws, like the laws of physics. On the other hand, the legal or positive rights have to be granted by an authority of some sort. Otherwise, they don't exist. They impose costs or demands on others, meaning that they can't apply equally to everybody. If somebody's got to be paid for by someone else, that can't be applied to equally to everyone. They can be removed at the whim of legislators, and therefore they're only ever temporary. That's a major pitfall of what people commonly call democracy. And they can be manipulated by power brokers to secure votes, get people to vote for them, and also to influence the legislators to their own advantage or the advantage of their supporters. Now, we're not going to go through the history of the common law at this stage. That was really basically existing for centuries, and it was codified by Alfred the Great. He was the king who unified England into one kingdom. It used to be several, and he was very responsible for establishing these common law practices throughout the country. But one point we need to cover, which causes a lot of people problems, is understanding the difference between lawful and legal. So let's go through these, a few points here. Lawful things stem from natural law, which binds all people equally. It's immutable, it's not susceptible to change or amendment, forms the basis of common law, overrides statute law. Something that's lawful overrides statute law, defines constitutional law and it protects individual rights. Now, there might be questions occurring in people's minds while we're doing this, so we will have a question and answer session later on. Legal, on the other hand, consists of, it refers to statutory legislation passed by Parliament or a Congress of Representatives. It can be changed by any succeeding administration. It favours a one-size-fits-all judicial process. In other words, they say, well, if you do this, the punishment's going to be that for everybody. There's no sort of taking into account the circumstances, or there's very little flexibility involved. But it's also, legal things are null and void if they breach constitutional or natural law. So what is constitutional? What is a constitutional law or a natural law? Here's my thing here. Let's go to the next one. No, that's not the one I want. Hang on. The cursor's only working on the big screen, not the little screen. Here we go. So when we talk about constitutions, the question comes up, well, who can write a constitution? And the answer is virtually anyone other than government, or everyone other than the government. The reason the government can't write a constitution is because we grant the government a monopoly on the use of force. Right? The rest of us, we're not going to use force. So the government gets a monopoly on that, and therefore they can't write the rules which also have to be enforced. Why isn't this thing showing up on here?
If you just hit enter, it should give you the next one.
Okay. Right, okay, thanks Tony. Okay, so the reasons why the government can't write the constitution is because the constitution must bind the government, not the people. The people are free basically to do whatever we like as long as we don't hurt each other. But the government, because it's got this monopoly of the use of force, must be constrained. Otherwise there's nothing to stop it from doing whatever it likes. So the government, nor any arm of it, can amend the constitution without the express consent of the people, right? And they must remain free to act in any way, and provided they abide by the 4 tenets of common law, which is do no harm, cause no loss, commit no fraud, and keep the peace. They're things that we're all morally obliged to do, and as long as we do that, we're free to act. So how do people actually control the government? There has to be some mechanism. We don't have that at the moment, do we? The government is basically acting like they're in control, and we have to do whatever they say. That isn't the correct way of doing it. When Magna Carta was first instituted, which formed the basis of the constitutional law, there was what we call trial by jury. And under trial by jury, an action for damages or for if someone has offended someone could be brought only by the person who was offended. They could report to a constable or an official, this person has caused damage to me, so I want to take action against them to get recompense. So the rule was, under Article 39 of Magna Carta, that should be decided by a jury. There weren't any magistrates or judges' courts. They're completely unlawful. Right? They're what we call part of the legal system, but they're not lawful. So under this system, the jury decides what's admissible as evidence. The jurors are the judges. So they may be assisted on points of law by an elected convener, someone who understands the law well. Jurors judge the facts of the case and the justice or otherwise of the legislation. The jury decides the verdict and the sentence, if any. the jury may annul the legislation and acquit someone technically guilty of a breach of the legislation which flagged the case. And a single juror may bring a publicly funded court action against legislators, singly or in plural, for any damage caused by legislation they bring in that causes harm to people. This is a system that was set up under Magna Carta in 1215. That's quite different from what we have today, isn't it? Where a jury, if there is a jury at all, which only occurs in about 1% of cases, the judges say, well, we're in charge, we decide what's going to be evidence, the jury will do what we tell them to do. They're not allowed, about anything the judge is not allowed to do is to direct the jury to give a guilty verdict. The jury's always got the power to acquit if they think that the evidence isn't sufficient. So,
Here's the enter.
beg pardon?
Here's the enter.
Enter, that's it. Now I'm not going to spend much time on this because over the years, Magna Carta established this system in 1215 when King John was running amok, and the barons sat him down and said, you've got to obey the law like everyone else, and Magna Carta was the result of that. Over the centuries, the elites or the people that run the establishment have worked to undermine that. And one of the things they did was go through this treason of the Bill of Rights. That was supposed to establish sorry, go back again. How do we get back? No, I'm going to move on because we're getting short of time. Another big problem that occurs, first of all, before we go into this, with the Bill of Rights, it established in statute the supremacy of Parliament. It said the monarch no longer had the right to deny royal assent, something which is completely unlawful and not justifiable, and that Parliament was therefore sort of in control of everything. But that isn't right, that is a treasonous act. The monarch under the Constitution is the umpire that decides whether a law that's passed or legislation that's passed is valid or not. And they've worked very hard over the last 800 years to try and nullify that. One of the things they did in Australia was produce the Australian Constitution of 1901. Now, this was an act of the UK Parliament in 1900. So we already covered that governments can't write the Constitution. A true constitution is written by the people. It institutes and guarantees the rule of law by providing for trial by jury and annulment by jury. And it provides for removals or suspension of the head of state or parliament for treason. In other words, treason is defined as the head of state or the people that are administrating the state, if they act against the interests of the people, remove their rights or do things like that, that's classed as treason, and the proper constitution has got a means of dealing with that. Magna Carta does have that, which we will come to. That's in Article 61. The Australian Constitution, on the other hand, was created by a parliamentary act. It asserted Parliament's constitutional supremacy over the monarch and the people via the judicature in Section 71, which states this, that the Commonwealth should be, the judicial power of the Commonwealth should be vested in a federal Supreme Court, to be called the High Court of Australia, and in such other federal courts as the Parliament creates, and in such other courts as it invests with federal jurisdiction. The High Court shall consist of a Chief Justice and so many other justices, not less than 2, as the Parliament prescribes. So that grants the power to Parliament, and there isn't any mechanism for the people to deal with that if the Parliament acts against our rights. It was voted into effect by a deceptive plebiscite whereby people were not properly informed of the issues at stake. The average person in 1900, when this was sort of voted in, didn't understand about our natural rights or about the purpose of constitutions, and so that information was withheld or just not provided, and the average person wouldn't have known about that. But those things are still there. Now, let's talk about democracy very briefly. what is democracy? Well, it is not suffrage or voting in elections. That always leads to some form of dictatorship, because the government starts interfering in the economy, things get out of kilter, people call out for more and more extreme measures, and eventually you wind up with something like what we've got today, where both the parties are arguing for the same thing, and they're not for our benefit. So that's an old definition. Now this gentleman here is David Robinson. He was the gentleman who first came to understand the meaning or the implications of Article 61 of Magna Carta being invoked in 2001. There was a group in Britain called the Magna Carta Society. They studied the Constitution, they knew all about these things, they knew that the British Parliament had been committing or passing treasonous legislation since the end of the Second World War, where they put these laws in that effectively granted more and more sovereignty to the European Union over Britain. And the British Constitution covers the whole of the British Commonwealth. So Magna Carta covers Australia, Canada, New Zealand, all these other countries. And David Robinson understood what happened when this was invoked. Article 61, which we've somehow missed here. I'm going to try and go back and find it if I can. But we've got some copies in here, so I won't bother about that right now. On here, which you can all get a copy, is Article 61. And that explains what to do if the monarch either permits treason or commits it himself. If he permits it by Parliament, then there are things that we can do. And there is a committee provided for a committee of barons that can suspend the monarch if they provide a petition to them saying this is wrong, what's going on, you've got 40 days to fix it up. And if they don't fix it up within that time, then there's a provision for the barons to distrain and distress the crown. In other words, to seize their lands and castles, not to pay taxes and so on. And we're actually all instructed, every person in the community is instructed in this article to assist the barons in doing that, if that is ever invoked, which it was on the 23rd of March 2001. And it was reported in the Daily Telegraph that that had happened, and of course that's an extremely serious event. The establishment decided we better try and keep this quiet. You can imagine what would have happened if the general public had understood that the Queen had been sacked and that the Parliament was no longer valid. We weren't supposed to do anything that they said. We didn't have to obey anybody that was claiming to represent the Crown. So this guy, David Robinson, understood these things, and he worked with a lady called Elizabeth Beckett, who was the daughter of a High Court judge in England who knew a great deal about the Constitution. He devised a series of notices that we can send to people who make demands on us despite the fact that this article has been invoked. So we will talk a little bit more about that later on. If you want to find out a lot about Magna Carta and the different aspects of it, this is a website that you can access, and that's the URL up there. You just have to type magnacarta1215.com into your search bar and this will come up. And there are all sorts of things in there, information about these articles, about the notices, the letters that we can send. Sometimes we send a notice to someone and they don't want to accept it. They think, oh well, no, I'm just going to obey the statutes that Parliament has passed. But that's not the correct thing to do. We rebut such letters. So our choice basically, now that this article has been invoked, is between freedom or slavery. We can understand our power, what the power that we've been given by Article 61. We can learn the truth of how to take action. And that's what our group does, is to advise people and help them in doing that. And we can create the world in which we want to live. That's basically what our responsibility is. Each person we all have a moral responsibility to behave in a way that's conducive to a prosperous and peaceful community, don't we? The only people who don't agree with these laws, natural laws we talked about before, about not harming people, not deceiving them and so on, the only people who don't agree with those laws are criminals, right? And we have criminals running the country at the moment. They don't care about those laws and they would like us not to know about it. So this is the choice that we have, basically. We have a few projects underway at the moment. One where we've sent a letter to every police station in the country and also to every council office in the country, explaining 12 points where they're behaving unlawfully, behaving in a criminal manner. And we ask them questions. What do they want to do about that? We let them know that we're trying to spread the word so that enough people know about that will cause a change in the community attitude towards the government. So I'll show you a couple of those. This is a constable's oath that they're supposed to do. This is the oath that the constable swears to uphold the peace of the king, and without favour or affection, malice or ill will, that they will cause His Majesty's peace to be kept and preserved, and will prevent to the best of my power all offences against that peace. Now, if you were really doing that, would a constable be following orders from a politician? Because if they're doing that, is that not showing favour to some people? The constable is doesn't need to take any orders from anyone, except maybe there's a huge sort of demonstration or something where they might need hundreds of constables in one location, so obviously they've got to be instructed to go there in that situation. But in a general rule, the constable doesn't have to take any orders from anyone. They're responsible for the execution of their office, solely responsible. They're only answerable to the law, not to the superior officer. Okay? So that's the constable's oath. Now, this is the point that we've come to at this point. This is something South Australian councils resort to selling properties to recoup unpaid rates. So this has happened in New Zealand as well. In South Australia and New Zealand, there's a thing called the LGFA, which is the Local Government Funding Authority. And that is a limited liability company to which all the councils in New Zealand or in South Australia have to apply if they want a loan. Now, if they do that, they sign a document stating that if the council defaults on its loan, they put up as a guarantee, the revenue of the council, right, which is basically people's rates. Now, what this basically means is that they can increase those rates as high as they need to cover those debts if they become out of control. And obviously, if people can't pay, then they wind up in this sort of situation where there are state statutes which state that if you haven't paid your rates for 3 years or more and they've tried very hard to get you to come to some arrangement, they can actually just sell your house out from under you. Now, that is unlawful, but the average person doesn't understand that. Here in Western Australia, I was checking up on this, and that doesn't apply in Western Australia. There isn't an LGFA. Here, if councils want money, they apply for grants. There are various types of grants they can apply for to the government. And of course, a grant doesn't have to be repaid. That's probably because WA's got a very good financial setup with the mining royalties. But they still have the same law where if you don't pay your rates for 3 years, they can start proceedings to sell your house out from under you. Even though there is no authority under the Australian Constitution or Magna Carta for local government in Australia. This has no authority whatsoever. It's just, you could each start your own business and calling yourself a council from a certain area and send out rates and so on, rate bills. It'd have no more validity than what the ones that are doing it now. So it is very important that we understand, get people to understand this. This is an article that was published in the Advertiser less than 2 weeks ago, where it's just describing what was happening there that I've just talked about, where homes were sold because people hadn't paid their rates for a period of time. And we need to get people to understand that this is coming. Right? The people who want to own everything, people like Klaus Schwab, that says you'll own nothing and you'll be happy, they want everything that we have. They're not going to be content until they've got everything and everybody who's left has got nothing and has to just do what they're told and live as slaves. So we need to get, our job is to get this word out, and that's what we're trying to do with these type of presentations, to let people know that this is what's happening, this is what's coming down the line. If these councils start getting their debts out of control and raising their rates to the point where people can't pay, and people are getting squeezed from the other end as well, aren't they? We're all getting squeezed with inflation, the cost of living going up, things becoming more difficult to afford. So we're getting squeezed from both ends, and we have a mechanism whereby we can stand against that, and it's provided to us by Article 61. And that's the, in fact, give you a copy of all of these right now. You can just each take one of those, and maybe take one and pass the rest on. And you can see on the back there, let me know if there's not enough there, but we've got enough for everybody here. So everybody, each one of you, should become aware of Article 61, what it says, study it, and we can ask questions about it. We're going to wind up now and we'll have a little break, and then we'll have a question and answer session. On the other side of that sheet is a whole series of QR codes and links which can give you loads of more information than what I'm able to fit into a half hour here. So thank you for your time and attention. Sorry we had those technical problems. They seem to sort of get mainly sorted out in the end. So thanks very much for your time.